everyone, I'm Nazarat Fatima and you're watching LiveLaw. A writ petition was filed by Adivasis for social and human rights action in the Odisha High Court regarding the rights of non-tribals to settle down in the scheduled areas. The election rights and voting rights were also questioned. A few contentions were made by the petitioners, which we'll discuss one by one. One of the major contentions made in the plea was that no one other than the members of the scheduled tribes have the right to settle down in the scheduled area. The other contention was that the people who are not the members of the scheduled tribes but are residing in the scheduled area are unlawful occupants. It was also contended that these people do not even have the right to vote in any constituency in the scheduled area. Moreover, the plea stated that any person who does not belong to the scheduled tribe should not have the right to contest the elections of the Legislative Assembly or the Lok Sabha in the scheduled area. Importantly, the plea stated that the Representation of the People's Act and the Delimitation Act are not applicable to the scheduled area in case the governor had not issued a notification as per the provisions of the 5th schedule of the Indian Constitution. The Odisha High Court, after hearing the matter, dismissed the writ petition. When the matter came in an appeal in the Supreme Court upheld the order of the Odisha High Court and dismissed the appeal. The Apex Court rejected the argument that the 5th schedule of the Constitution takes away the right of a non-tribal person to settle down in the scheduled area. The matter was heard by a bench comprising Justice A.S. Oak and Justice Rajesh Bindal. The court observed that every citizen has the fundamental right to reside and settle in any part of the country, despite the fact that in certain cases reasonable restrictions can be put on some fundamental rights. As such, the Supreme Court rejected the argument that non-tribals do not have the right to settle in a scheduled area. The Supreme Court also said that the argument that the 5th schedule is a law made by the Parliament is misinterpreted. It said that even if it is assumed that 5th schedule is a law, it still does not interfere with the exercise of the fundamental rights. The Supreme Court, after analyzing the case, concluded that all the central and state laws which are applicable to the entire state of Odisha will continue to apply to the scheduled area unless the governor notifies that an enactment is inapplicable, either fully or partially. The court also said that the power of the governor under the 5th schedule is restricted to directing that a particular law will not apply to the scheduled area or it will apply with modifications. With respect to the fundamental rights, the court said that the power of the governor does not supersede the fundamental rights. The court rejected the argument that no one other than the members of the scheduled tribes have the right to settle down in scheduled areas. Importantly, it noted that since the Representation of People's Act is applicable to scheduled areas, every eligible voter residing in the scheduled areas, even those who are not members of the scheduled tribes, can cast their vote in elections. The court also noted that all the constituencies in the scheduled area cannot be reserved for the scheduled tribes only. As such, the Supreme Court dismissed the appeal and said that there was absolutely no merit in the appeal and the High Court was right in rejecting the writ petition. That's all about it. We hope you like our content. If you do, please like and share. Also subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.